The big story we're currently tracking, 2 days after firmly defending the country's colonial-era sedition law and asking the Supreme Court to dismiss the pleas challenging it, the government did an about-face, saying it has decided to review the legislation. Now, the Supreme Court is currently hearing the plea. The Supreme Court has asked the centre, how long will it take to review the law? The centre's lawyer says we can't give a review timeline, to which the Chief Justice of India says we cannot give unreasonable time for review. The CJI has added, it should not appear that we are unreasonable, further adding that there are concerns about pending cases as well as misuse of the sedition law. Now, the Chief Justice of India, currently in court, has also said, how can someone stay in jail for months? The CJI questioned the centre and asked, if your affidavit says civil liberties, how will you protect those? The Chief Justice of India has also added that as far as the Gopal Sankar Narayana case is concerned, we have to look at both sides. When the affidavit says PM is cognizant and has often spoken about civil liberties as well as human rights and diversity of thoughts, on the 75 years of independence, what is the government's action plan? The CJI was also cognizant that there needs to be a balance. He says there are people who are in jails, even future cases. Please make your stand clear on that. This is what he asked the Solicitor General. Right. To provide further clarity on the matter, we are joined by Ashwini Dubey at the moment. Ashwini Dubey, I just want to ask you, many are questioning why the government's move came on the eve of a solution.
Yeah, see, the fact is that Supreme Court is looking after the Kedarnath judgment, whether that uphold the constitutional validity or not, one. And the second, Supreme Court has already made it clear earlier that the sedition law, which needs to be revisited because this was passed by the Britishers in order to suppress the voice of the freedom fighters. Now, three, even in the British era, Britishers have abolished this law. Now, moving further, the central government senior most law officer Tushar Mehta had earlier filed a note before the court stating that Kedarnath Singh judgment has stood the test of time and was applied till date in tune with modern constitutional principles. So, only a bench of co-equal strength of Kedarnath Singh can pose any doubt on the verdict. But contrary, the Honorable Supreme Court says how under the sedition law, somebody can remain inside the jail for years. See, what we have to look into, there is the Article 19(1)(a) of the Constitution of India also lays down certain principles where the freedom of speech and the right to express opinion, freedom of speech has been given as the fundamental rights, and various judgments have been passed by the Honorable Supreme Court. Keeping in with that, in order to suppress the voice of dissent, some of the state governments or sometimes the other governments may invoke these provisions, ignoring that the constitutional remedy is available. So this time has come where the Kedarnath Singh's case, where the Honorable Supreme Court has upheld the constitutional validity of Section 124A being available on grounds of this, and subsequently R.C. Cooper case also came. So thereafter, keeping in view this Article 14, 19(1)(a), 20 on the Constitution of India, and in the larger public interest, in the interest that speech should not be chilled in a free democratic republic like India, the Honorable Supreme Court is looking into it. And you see the yesterday's affidavit of the Supreme Court, the Government of India, where the Government of India has said that the Prime Minister at the 75th year of the freedom in Amrit Mahotsav have taken a view that they will consider it.
Right. Also, news just coming in, the CJI has told the centre that we will give you time till tomorrow morning to take instructions from the government. My colleague Sukirti Dwivedi is in court. She's closely tracking the story. In fact, the order says in order to protect the interest of people who are already booked under sedition law as well as future cases, centre to file a response on whether those can be kept in abeyance till law is re-examined. The centre will file its response, its reply by tomorrow, and the next hearing is tomorrow. With that, I want to revert to Ashwini Dubey, please. Ashwini Dubey, what would you say to your critics actually, who claim that the sudden move to decide on a review of the law was just a ploy to buy time?
See, maybe, but ultimately the question remains is that when the Constitution bench of this Honorable Court in Kedarnath case has upheld the constitutional validity of sedition law, then that what is the, as per the Supreme Court mandate, what is required, that either the 5 judgments which can give the the contrary opinion of the Kedarnath case, or it should be referred to the larger bench. This question which is here, and that too at a time when the government of India has taken a view that the Prime Minister has said that he will revisit, look into it. So I don't think that they can not take a decision. Government of India has ample powers to take a decision. By executive order, even the sedition law can be stayed for the time unless and until the government of India passes a clear law that whether they are willing to abolish it or certain parameters are to be let down, keeping in view today's scenario. What has happened in number of cases, sedition law has been misused and people are behind the bar. The recent episodes also we can see, earlier also, in past also, the government in power, be it any government, has been misusing and abusing this law. So time has come where either the Supreme Court look into this and refer it to the larger bench, like 7 judges bench, or the government of India may come with a solution with the parameters as suggested by the Attorney General that look, we need to revisit it, and either if you want to uphold this, keep this law in the Indian Penal Code, then you have to set the parameters in today's era, because this was brought in order to suppress the voice of freedom fighters in colonial era.
All right. Then I just want to ask you, what would you say to those who claim Section 124A is no longer what it says to be in print? Many would say it's been read down and is very limited and restricted in its application.
See, this Section 124A would require an interpretation of Article 19(1)A in correlation with and taking color from Article 14 and 21, which require the law to be both substantially and procedurally reasonable. So the Constitution of India is also here, and there is a thin line between 19(1)A and 124A that has to be looked into, and I think that the top court of this country may decide it, that what constitutes the freedom of speech and expression and what constitutes the sedition. That has to be seen and that has to be looked into. And in the says the Constitution bench decision does not stand in the way of the Honorable Supreme Court in way of this considering the constitutional validity of Section 124.